Welcome to Garden Views, interesting conversations with interesting people who have done and or are doing interesting things. So sit back and enjoy.
Welcome everybody into Garden Views. Today we've got two guests and we're going to be talking about death and taxes, two things that are very scary. So this is definitely ripe for Halloween. Before we get started into this legal themed episode of Garden Views, I need to remind everyone that this is for informational purposes only and not to take this as legal advice for yourself. You are certainly advised to engage and talk to your own legal counsel. Whether or not that's one of these good folks, that's up to you, depending on where you are and where they're licensed. So our two guests one is a returning guest and somebody I've known for a number of years, Burlington, who formerly was in Maryland but is now in Oregon, and she's been on the two Star Trek shows and the cannabis law show and probably something else too. But Elle, tell the good folks about yourself, where you're working, and what you do.
So I am mostly working these days in entity formation, transactional side of things with some tax controversy and a little bit of planning. I'm at a firm called Solar Whitman Cooper. It's in Lake Oswego, which is a suburb of Portland. It's where all the generic office buildings are, but that's okay because there needs to be some generic office buildings somewhere. It can't all be whatever Portland is. So, yeah, I practiced in Maryland for a while, and then I moved out here about 6 months ago. So, just living my best life.
Excellent. And our other guest is Rob Owings. He's licensed in Maryland, Pennsylvania, and the District of Columbia. Rob, tell us a little bit about yourself.
Hi, my name's Rob Owings. I had the pleasure of working with Elle in Maryland when she was here. I've got my own law firm now. I do mostly estate planning, administration, litigation. Those are basically all estate-related matters. Also do some business planning, as I've discovered that, when you're dealing with estate plans for people that own businesses, it's a natural transition to be able to include that as well. So those are the two matters that I really focus on.
All right. So, folks, we're not covering the flyover states today. Wrong, we actually are, because we're going to be talking about federal estate taxes, which are, as you heard, federal. Now, some states also have inheritance tax and probably other, what's the word I'm looking for, idiosyncrasies. So that's one of the reasons why you need to talk to your own attorney in your own place. So we're going to try to do this as sort of a 30,000 foot to 10,000 foot view. And so, Rob, I think I'll ask you to start. What are we mostly talking about here, and what are we trying to do?
Well, the topic of discussion really is the estate tax in general. Speaking at a federal level, the estate tax is a tax on the entirety of your estate if it's over a certain exemption amount. And it's a significant tax. It gets up to 40% really quickly. As of this year, the estate tax exemption per person is $12,060,000. Again, a pretty significant exemption. However, something to keep in mind is in 2025, the current laws are set to sunset, and the exemption is going to drop back to 3.5. That's if, of course, as of any law, right? It's good until they change it, but that's the way it exists right now. So I heard, and I can't tell you how many occasions in 2010, when the last time we had an estate tax law that sunset, every single person was saying, there's no way they're going to let it expire. There's no way they're going to let it expire. And immediately what happened, 2010, the estate tax law expired. So for the year 2010, there was no estate tax. Coincidentally, George Steinbrenner passed on, I believe, January 1, 2010. So the federal government missed out on 40% of a few $1 billion. So I'm sure that's why they may not let it slide again.
The Steinbrenner rule.
Yeah, and at any rate, it's a significant exemption amount, but when you're over that exemption amount, it's a significant hit. And it's a hit also on money that you've already paid tax on, for the most part. So it's your entire estate. So to the extent that was earned income, you tax when you earned it. When you get over that exemption amount, you get hit again for another 40% if you're in that category.
Right.
And again, The exemption now at 12,060,000, which is indexed for inflation. That's why it's an odd number. Not as much of a concern, but if it does sunset in 2025 and that drops by 75%, now all of a sudden a lot more people are going to be involved in this.
What about if you're married?
So if you're married, there's a concept that was introduced in 2012 called portability. And what that says is, okay, you have spouse A and spouse B, each this year get $12,060,000 of exemption. Portability says, okay, we're not going to tax the first spouse's passing, but what we're going to do is say when the second spouse passes, they just get double the exemption.
Okay.
So nothing at the first spouse's death, the second spouse gets 24,112,000 base. That's it. That happens this year, and then of course index for inflation going forward.
What about long time? I'm sorry, go ahead.
No, I was going to say portability did away with a lot of the old AV trust planning where you had to, each exemption was individual. You had to carve out that exemption amount, set it aside so that you didn't lose it, and then do it again at the second spouse's death to make sure each exemption got captured. So portability actually simplified that a little bit.
Yeah.
So what happens, there's a situation with more than one spouse, like a widow remarriage situation? Like, how does that work?
Well, it depends. So you have to, one of the things that you have to do, and this is where people slip up a lot, is in order to preserve portability, you have to file a tax return, even though nothing's due, and select portability at that first spouse's death. And there's a thing called a deceased spouse unused exemption amount, DSUE. I don't know why they use that acronym. It doesn't spell anything, but there it is. And so that amount is kept by the surviving spouse, and remarriage won't affect that from the standpoint that they can use that, but then they can't use, so you can't use multiple spouses. It's one or the other.
Right. What about if you are long-term partners in a state that recognizes common law marriage versus one that doesn't?
If it's common law marriage and you're recognized as married, then it should count as that. I mean, that's a state-specific issue, obviously, and one you want to look at that. Because to your point, I happen to have taken the bar and gotten licensed initially in a state that does have its own estate tax regime. So that's something that you definitely have to check in each state. Like you said, I started out in Maryland, which has its own estate tax regime at $5 million exemption apiece, not indexed for inflation. There are some that have none at all. There are others that just say, well, whatever the federal exemption is, ours is the same as that. And so you really have to take a look at that. And keep in mind, it's based on upon where the person passing was domiciled.
Right.
So if you pass in a state that has a state tax, but you're leaving it to children that live somewhere else that doesn't, it's still subject to a state tax because you pass in that state that does have it.
Right. So it gets risky, and common law marriage is sometimes contested and not as clear as maybe you'd like it to be. What about just long-term partners that are long-term same-sex or opposite-sex, non-binary partners who, they've never got married, they didn't do a domestic partnership registration where that exists, and there is no common law marriage?
Well, in that case, it's even worse because what happens there is if there's no agreement in place, no common law marriage, no domestic partnership, then they're treated as a friend, basically, and that could also subject them to an inheritance tax if that exists.
And my last question, and I think I know the answer already, but this is, what about gay marriages if, in fact, the Supreme Court reverses that, which, a few months ago nobody thought was thinkable, and now all of a sudden it's possible. So I assume that would revert the status of those couples back to friends?
Either that or they would have to grandfather it in somehow.
Okay.
They would have to say, we're going to make it effective as of this date. If you were already married, you're still married. We're not going to go back and reverse all that. Given the way that they've treated things like that in the past, I would suspect there'd be some kind of grandfathering and say, we're just not going to recognize it going forward. Because I can't imagine the legwork involved in going back and trying to reverse it. Yeah. For as long as marriage has been legalized, that would be a disaster. Because if you think about it, then you're looking at all those income tax returns for those years, and all those other items associated with other things that would also have to be reversed. And I can't imagine the government even being able to do that, let alone wanting to. So I would think it would be some sort of grandfather situation where they say, okay, we're reversing gay marriage as of this date going forward. You can't do it anymore. If you were married prior to this date, then you're married.
So you're saying retroactively would not apply, but prospectively, you're just friends.
Yeah, I mean, that's the way I would think. I mean, I don't know, because we'd have to, hopefully, who knows what's going to happen, but we'd have to see what they do if they actually did reverse them.
Okay, gotcha.
Just like that could have same-sex couples that have been married for years and years and filed, 18 joint tax returns. They would have to go back and say, now, none of those are valid. And I can't imagine the administrative nightmare associated with that.
No, I agree.
Well,
go ahead.
And plus, you'd have the issue of the state versus federal thing, assuming that they invalidate it federally, and then it goes back to the states. Like, what's going to happen there? That's always something fun to think about. So
correct. Yeah. Because there was another topic recently. The same thing happened, and they kicked it back to the state, and my state just said, "Well, guess what? We're not changing anything." So that decision didn't really affect anything.
Right. But people do move, and as you
Correct.
pointed out, there could be heirs in other states as well. Okay. So we talked about estate taxes and we talked about inheritance taxes. Just quickly, what's the difference? I know we're not going to cover all of the states by any means, and between all of us, we're licensed in probably a total of 6 jurisdictions with overlapping Maryland, DC, and probably just overlapping Maryland and DC. So just generally, what are the differences? I don't know which one of you wants to handle that one.
I can take that for you. So estate tax is the tax on the entirety of your assets owned individually by you and your house. So it's just basically they sum up everything you own, and they say, okay, here's the amount. Is it subject to tax? If so, what rate, and so forth. Inheritance tax is on the person receiving the items. And the reason that is because in most states, a lot of them anyway, but again, this is state specific, you'd have to go look, but what happens with inheritance tax is some people are subject to it and some are not. So, like, for example, in Maryland, if you leave things straight up and down the family tree, kids, grandkids, great-grandkids, so forth, they don't pay inheritance tax, and siblings don't pay inheritance tax. But if you leave something to a niece or nephew, they pay inheritance tax of 10%. So that's just an example.
Or your friend or your new friend that was your spouse a year and a half ago.
Correct. And they would then be subject to that as well. So yeah, it's something to keep an eye on, because at least with the inheritance taxes I've dealt with, there's no exemption. If somebody leaves you $1, you owe the state 10%. I mean, so there's not an exemption for that. But again, it could be a situation where you have an estate where some people are subject to inheritance tax and others are not.
It looked like you had something to say.
Yeah, I guess part of the question in terms of size of estate is, and this is one thing I was never able to really wrap my brain around, was how lifetime giving factors in, because there's the yearly threshold, which seems to keep getting adjusted for inflation. I think it's 16,000 now.
16,000.
15,000. So the premise being that you can gift to and correct me when I'm wrong, because I know I will be, you can give to any one individual up to $15,000 for value thereof, or property value thereof, without being subject to gift tax. You still have to file a return. I'm going to leave this all to you.
No, actually, what they actually call that is the gift tax exemption amount. And the IRS says we're not even going to count that as a gift. We're just going to say that's your exempt amount. You can give that per person per year. Again, 16,000 this year. And as long as you stay at that amount or below, then we're not even going to count. It's when you give something in excess of that value to the same person in a year, then you have to file a gift tax return. It's just Form 709. And what happens is, let's give 50,000. Your return will show you gave 50,000. They'll subtract the $16,000 allowance, and the taxable gift is 34. And what happens? Your lifetime exemption works in tandem with the gift tax. So let's say you have, I'm going to use 60,000 because I don't like the math building. I never went near it. So 12,060,000. Let's say you give a $60,000 capital, or taxable gift rather, and did they take off the 16, so you still have 60,000 left? And what happens is when you pass away, they go back and look at your 709s of what gifts you gave during your life, and that gets subtracted from your exemption. So if you gave $60,000 worth of taxable gifts and filed your 709s properly, what happens is your exemption will now be $12 million instead of $12,000 because you gave away that much during your lifetime.
Okay.
Now, where that comes into play is, if you give away something that's going to appreciate in value, what happens is that appreciation is not part of your estate. So if you give away $60,000 worth of stuff and it appreciates to, $100,000, well, $40,000 of that is not part of your estate tax liability. So it's basically the appreciation that gets out of your estate when you give something.
What about you? We were talking about estate and inheritance tax. So if I understand correctly, inheritance tax is on what goes through probate, but estate tax may be beyond that. Is that correct?
No. Probate is just whether you use trust or a will. Estate tax is, here's the total amount of things I own. This is the dollar value. Is it subject to tax or not? So for this year, if you have $11 million worth of assets that you own at your passing, and the exemption is still $12,060,000, well, then you don't owe any estate tax. Inheritance tax is on the person specifically receiving it and their relationship to you. So, you can only have $1 million estate, but if you leave that $1 million estate, for example, in Maryland to a nephew, well, then he's going to owe the state $100,000 worth of tax.
What if you have an estate over the amount, but it's...
They'll have taxes.
I'm sorry, I was talking over you. Can you repeat that?
Oh, yeah. It's based on the relationship to the decedent.
Okay.
So again, for a Maryland example, because they're one that I know has an inheritance tax regime, if I have a $10 million estate, or let's say $4 million, just to keep this estate tax stuff out of it. So let's say I have a $4 million estate, I leave it all to my children in Maryland, no inheritance tax. If I leave it all to a nephew, $400,000 worth of inheritance tax. If I leave, $3.9 million to a child, no inheritance tax for that child, but I leave $100,000 to my nephew, he still pays $10,000. So it's based on the relationship to the decedent. And inheritance tax, there's no exemption. Like I said, somebody $1, they owe $10.
So, and this, and you can forgive me if I get this wrong. Is it also a question of who pays the tax?
Normally, if you're estate tax, that'll be paid before anything's distributed. And the inheritance tax is paid by the individual because, again, it could be very likely a scenario where some people that are inheriting from the estate are subject to inheritance tax and others are not.
What about in the case where somebody, they don't have much in their own name necessarily, but they had a significant life insurance policy or a 401k or IRA or some combination where you have a pay on death or death beneficiary? Is that calculated into the inheritance or the estate tax if it never goes through a... Go ahead, sir.
Yeah. Estate totals, yes. It's not counted into the inheritance tax would count as far as IRAs and so forth. Life insurance you receive as a tax-free benefit. That's one of the benefits of doing it. So that's one reason to do life insurance, but an IRA and stuff would be subject to that. So technically, that stuff is owned in your own.
Okay. So life insurance, if you have the choice, life insurance is the way to go. But obviously, most people, you get a 401k or IRA partially through work, and there's other advantages to that. But that would count if you have a lot of money in those types of assets. You probably want to think about some type of estate planning.
Oh, 100%, yeah. And especially if you're charitably inclined. I mean, I tell people this all the time. If you have retirement accounts and you're charitably inclined, that's where you leave all your charitable stuff. Because they're not going to be subject to the income tax anyway, so what do they care?
Right.
So it's an analysis basically of who am I leaving it to, when are they, and so forth. Or again, let's say for example here you wanted something to your niece or nephew, well maybe you don't do that out of a retirement account, that out of your other assets, leave your retirement account elsewhere. So there are ways you can finagle who gets what if you want to divide it up and so forth.
Right. It's called planning. You have to plan.
Then accurate.
And you have to do it before you lose capacity, and certainly before you lose your life.
Exactly. That's one thing I always tell people. The reason to do this is because you can't fix it after the fact.
Right. Elle?
Yeah. So also, at least, and I say this mostly from like a personal point of view. Like there are members of my family who have done life insurance funded trusts where the trust doesn't, the life insurance is payable on death, but then it goes into a trust for a survivor's benefit. And that's one tool that that always sticks out to me because it was such a large part of estate planning in my family. But I just thought that was interesting to point out that that could happen as well.
Yeah, that's an interesting way that people use to get around the estate tax. If you set it up properly, you set up what's called an irrevocable life insurance trust. The trust actually buys the policy, and the person, whoever the grantor, pays the premiums to the trust as a gift. So it's actually a double hit. You get to give that money to the trust. So if you stay under your $16,000 per person per year, you're depleting your estate in that way. And then what happens is, since the trust owns it, and again, this is because it's irrevocable. Revocable trusts don't accomplish this. Because it's an irrevocable life insurance trust, the trust as a separate entity owns that policy. When the policy pays out, it goes into the trust, and therefore it's not part of the taxable estate of the individual in question.
What about a case where the trust is the beneficiary of, say, term life insurance?
Well, that you can use that in an irrevocable life insurance trust, and you want in that case you specifically want the trust to be the beneficiary because that's how it keeps. So let's say I set up an irrevocable life insurance trust. I maximize my gifting, so I'm paying $16,000 in premium a year, which can give you a significant amount of life insurance. And I put it in that trust. The trust owns it. I gift it to the trust. They use it to pay the premiums. When that insurance policy hits, the trust will determine who gets what out of that, where it goes, and all that stuff. But it will not be that amount of the insurance benefit is not part of my taxable estate. So not only have I given, let's say it's a $5 million payout that's not subject to estate tax, I've also depleted my estate by $16,000 per year by paying into that trust to fund the premiums.
I think we should probably do some basic definitions. Two would be what's the definition of an irrevocable trust versus a revocable trust? And also just basically what is probate, knowing that there's 50 states and other jurisdictions that might have different aspects to probate, but there's probably a high level definition just so people know what the words mean that we're stating.
Sure. So an irrevocable trust is actually a separate entity. And the reason it's a separate entity is because once for example, the life insurance trust we were talking about, once I put my money in there, that's it. I cannot get it back. It's given to a separate entity. It would count as a gift if I go over that $16,000 per person. That's why it's not subject to estate tax when I pass. But like I said, the downside is, and an irrevocable life insurance trust is just one brand. Any irrevocable trust, when you give something to it, the reason that you can get some of that stuff out of your estate is because it's a separate entity, and when you pass, it's not yours. It's not part of your estate. But the trade-off is you have to give up control of those assets during your lifetime. So it's not a situation where you can give stuff to an irrevocable trust and then take it back and put it elsewhere. You can't do that. Once you give it, that's it. A revocable trust is just a will substitute designed to keep you out of probate. It has a couple other benefits too. It's private. A will is a public record. A revocable trust is not. But for tax purposes, IRS purposes, gifting purposes, a revocable trust is you. And so it's seen as your asset. It's included in your taxable estate. And the reason is the revocability. You can put stuff in your revocable trust. You can take it out. You can tear your trust up, say it doesn't exist anymore. The key word is revocable. If you have the right to revoke it, then the IRS says, well, you really control it, therefore it's still yours. Therefore, it's part of your taxable estate. And then probate. The final word is probate, and that's the one where what everyone tries to avoid. That is the process by which your will is filed with the state in which you reside. And to your point about each state being different, not only is each state different, sometimes the states the counties rather in each state are different. So it's really based on the county in which you reside when you pass. So, and again, if they're in the same state, they're usually very similar, but sometimes there are little differences in processes and so forth, but it's actually county-based rather than state-based. And that's the process where you file your will with the county. They say, yes, this is a valid copy. They appoint someone personal representative. And then you're subject to all the rules about, what papers have to be filed, date of death valuations, information reports, inventories, accounting. It's a lengthy process, and it's not an intuitive process, right? It's not something you can go look at and say, oh, okay, this is easy. No, it's definitely dealing with the government process. Takes a long time, can be quite the headache. And again, wills are public record, right? I mean, you can, if you have a will and once you pass it, it's filed, anybody can pull it out.
Well, I kind of have a question because you were talking about probate. Imagine that my sister and I have a falling out, and then our parents die, and I decide that my sister doesn't deserve any money, and my parents must have been crazy. Like, at what point do I have a right to challenge it? Do I have a right to challenge it? Because you see all the, like, I guess a lot of the stereotype is, right, the grandma dies and leaves all the stuff to the butler, and then the children get really upset and they challenge the will. So, how often does that happen, and like, what's the process by which it would happen? Like let's just say in Arundel County, Maryland, or somewhere where you worked like before.
Yeah, the process is called a will caveat, and it basically is saying, hey, this will's invalid for some reason. Either the people were under duress when they did it, or they weren't of sound mind, or some other reason, that the will shouldn't be considered valid. It wasn't executed properly, so forth. So basically, it's a challenge saying the will doesn't exist. It shouldn't exist. It shouldn't be allowed because of X, Y, or Z. That's a will caveat, and it's filed when the will is, when the will is filed, and then you say, because it technically, until someone dies, their will is not really in existence, right? Because as long as they have capacity, they can change it up to the day they pass. So the will caveat will come in when it's filed, and you say, okay, well, this can't be right because my parents must have been crazy. My sister shouldn't have inherited anything. I'm going to file a will caveat and challenge it. The most important thing to look at there is standing. You have to be somebody that would have inherited anyway. For example, I couldn't go file a will caveat against your parents' will because I wouldn't have inherited regardless, right? So the judge would say,
never know. My parents would be generous.
Well, there you go. But yeah, that's a situation where the judge would say, hey, you don't have standing this is not your concern. But you, for example, could, because you could say, hey, I know for a fact my parents were not mentally with it, or my dad was diagnosed with Alzheimer's 5 months before he signed this will, and here's the medical paperwork saying it. So something along those lines where you would be able to prove that, hey, for some reason, this is not valid. And the term.
Go ahead.
Oh. I'm sorry. I feel like I'm getting a little far afield with this, but I just think of situations mostly where we see it dramatized, like where if you declare a will invalid, what happens?
Well, there's a couple things that can happen. One is if there's a prior will. So let's say your parents did a will when you were born, and then they did one 2 years ago. Well, you figure out that the one from 2 years ago is invalid because of something like I said, like maybe somebody had Alzheimer's or somebody was diagnosed as something other than being able to effectively execute a will. You get that one thrown out. If there's a prior will, the prior will will then take the place of the one you got thrown out. If there's not a prior will, then you look into laws of intestacy, which is intestacy is just the legal term for, hey, you died without a will. Right. So what'll happen is they'll look for, so if you get a will kicked out, they'll look for a prior will first. If there is no prior will, then you're subject to your state's law of intestacy, which is basically just a flow chart that the state says, okay, here's who gets what if you don't have a will. Here's how it flows.
Challenges to estates.
Can I get the court to say that I get that painting and not my stupid sister?
What's that?
Can I get the court to say that I get that painting and not my sister? Like, can they make that kind of call? Like, I'm thinking of a situation like where you ask for declaratory judgment in the context of a civil case where you say, I want the court to specifically say X or Y. Even taking out of account intestate succession and prior wills, can a probate judge do that?
Well, won't, though. What they're going to say is, all right, you got this will kicked out, therefore there is none, therefore here are the laws of intestacy. Each person gets this. And they will do their best to equalize. So, for example, if your parents pass with no documents, it's just the two of you. Again, I can't speak to every jurisdiction because every state is different, but Maryland's flip chart would say you and your sister split everything.
Right. I mean, technically, the probate courts are courts of equity, so I suppose they could, but they probably wouldn't unless it was the situation where you got the newest will invalidated and the prior will did have that painting going to you. Otherwise, usually they let the personal representative or executor make that decision. And if you don't like the if you don't like the executor, sometimes they'll appoint a third party executor who will get to make the decision. But challenges to the estate, I mean, they can come from a lot of places, but generally they fall into two buckets. Family, and the other bucket is creditors. And then sometimes you have that blurred line where you have a caretaker, which maybe is family, maybe is extended family, or a caretaker who's been doing it sort of on because they were made promises, or some other creditor. Usually, unless it's a very large creditor, they're not going to make a claim against the estate. Your typical credit card bill of $5,700 or whatever probably isn't going to, but I guess it depends on the creditor. But the IRS will, if you have a large judgment, they will. If it's a big business dispute regarding your 50% of an LLC, your former partner might. So you usually know if there's trouble in the bushes, but you don't always know. And part of the probate process, probably everywhere, at least in my jurisdictions, is that you have to put notice into a paper, and there are claims that can be filed against the estate within X amount of time. In Maryland, it's 6 months. And so another aspect is that the estate isn't exactly liquid until at least that period of time ends, and technically not until it's finally approved. So there's a lot of wrinkle. Things don't go wrong with probate, often per rule, but when they do, they usually go really wrong.
Yeah. And to your point, it's actually two slightly different things. Creditors aren't trying to validate a will, they're just saying, hey, we get paid first.
Right.
Whereas, family is usually saying, okay, this will is not invalid because I didn't get what I wanted. Right. But to your point, yes, that's exactly correct. Either way can cause depletion of the estate and cause problems and delays. And I always tell people this about probate. Your estate tax return on the federal level is not due until 9 months after you pass. So what does that tell you? They're expecting it to take 9 months. Right. Or that long to figure all this stuff out.
I also confirm this for me or correct it, but Elle was talking about a will challenge. So a will challenge, the will really doesn't mean anything until after you're deceased and it's submitted to probate. So the challenging of the will starts after that, which means that you are dead. The will is your dead person's testimony. We call the dead man's rule. If you do your trust, it's alive, and it's alive the moment you sign it. So the statute of limitations to challenge it presumably starts before you're dead, and quite possibly many, many years before that. So the statute of limitations might be over, especially if you've transferred like a deed or something like that where there's public record of the existence of the trust.
Yeah, but they won't. The terms of the trust upon inheritance are always dated as of your passing. So it'll say, this person doesn't get my assets until this happens and I pass. And that's usually when they start the clock. So it's almost always a concurrent run. But yeah, to your point, the real issue comes up when, what if someone's alive, but they have their assets in trust, but they're incapacitated? Well, a trust can govern that, whereas a will can't. Will doesn't kick in until you pass. Right. Whereas a trust, okay, I'm alive, but I'm incapacitated. I can't change anything. I can't do anything. But I'm not deceased, so my estate hasn't been done.
So statute of limitations doesn't start to toll until somebody's goes from being a theoretical beneficiary to actually being a beneficiary.
Correct. Because and the reasoning being is that it could be changed. Right. So you Elle, to your point, if you challenge your will, saying your sister shouldn't get anything, well then 6 months later your parents changed their will. Well, there was no point because now they did it the right way, obviously. So yeah, that's the reason that clock starts upon the publication of the will.
Okay. So the main thrust of this show, I mean, I think we need to go through some of the definitions and whatever, but what are some of the strategies employed to avoid taxes? And if you don't have an estate that's anywhere near $12 million, why should you be paying attention to this?
Well, you should be paying attention to it really because of the sunset provision right now. It's $12,060,000 today, but in 3 years it could drop by 75% or more. I mean, like any tax law, right? It's good until they change it. So it's worth keeping an eye on just in case, given the current environment, and just in case somebody goes through and says, well, you know what, we could collect a lot more money if we start taxing the states that are worth, $1 million instead of 12. Given that the rate's so high, we could just drop that exemption. And additionally, we could do that and say, well, we didn't raise the tax rates. We just lowered the exemption. The tax rate's exactly the same. So that's a reason to keep an eye on it. Again, because of that sunset, we know it's coming in 2025. But it could be before that. And again, it could be even more significant. It could drop all the way down to, there was a time when it was $600,000.
I remember that time.
Yeah, when I was a baby in this industry, that's what it was. It's but anyway, the point is it's good until they change it, right? So one of the strategies we covered, the most basic, the easiest, is gifting, right? I'm married, my spouse and I can each give $16,000 per person per year. Doesn't sound like a ton of money, but let's say you have 4 kids. Well, now I can, and there's a concept called gift splitting, which means if I give money and I'm married, it's assumed that it came from me and my spouse, so I get to double everything. So now all of a sudden, if I have 4 kids, I'm giving $32,000 per kid per year. Well, you can see how you can shove a lot of money out of your estate that way. And it's not limited to children. If you wanted to give nieces, nephews, whoever, as long as you stay under that amount, you get that $16,000 per person per year, and just you can really funnel a lot of money out of your estate. Now, what's the downside? Obviously, you can't get it back. That's it, right? So, but if someone's close to the limit, like let's say you have $13 million, well, it'd be pretty easy over a few years to funnel out enough money to get you below that exemption.
You can even give it to me.
Yeah, right. I'm willing to take donations. Mm-hmm. I work for the Me Fund.
Yep.
And we covered life insurance trust. That's actually a very common one. Again, you set up an irrevocable trust. The trust buys a life insurance policy on your life for the benefit of the trust. You gift the premiums, they buy all the insurance they can buy, you pass, the benefit amount goes into that trust, and then you can dictate what happens to it after that. It can be, benefit children for their lifetimes, go outright to people. Point being, though, is you've taken, $16,000 or whatever it is a year that you pay in premiums, and you've leveraged that into a much more significant number through the insurance, and it's not subject to estate tax. So that's another thing it can be used for, is to actually pay the estate tax. So let's say you're way over $12 million. You buy a bunch of insurance, you have estate tax. You can use that life insurance trust can actually pay that bill. So that cash, when it hits, can be used to pay that bill. Go ahead.
With an irrevocable trust, you can't be your own trustee, though, correct?
Revocable, yes. Irrevocable, I would say not to. No.
Okay.
Because then argue, hey, this is really still yours because you're asking yourself for money at this point. So I always recommend that it's not you for your.
What about like your spouse or your kids or, someone that's particularly close to you? Liz, there's no reason for you to be barking at us.
I know. He's going a little crazy.
Oh, it wasn't in the Hell's Dog. Sorry.
Oh, no. She abandoned me because her mom just got home. So she ran away.
I see.
Mine is someone apparently dared to drive down our street.
Oh, my goodness.
Yeah, I know. I can't do that nonsense. But anyway, so yeah, the irrevocable, I would always say try to have an uninterested party, corporate fiduciary, attorney, somebody else that you can make legitimate claim, hey, I'm not asking myself for money. This person really has the control.
Okay.
Because again, you get into the thing where a lot of people like to do it, where they have their spouse do it, and then an argument can be made. Well, is that really control? In some cases, maybe it is, but who knows? The point is that I would say that it's better not to have somebody that's an interested beneficiary of that.
Especially if you're worried about that gold digger next spouse, that you're worried about Fabio or Anna Nicole sweeping in and charming your widow or widower.
Yeah.
I wanted to ask about powers of attorney and healthcare directives and where they fit into this equation.
So powers of attorney only exist while you're alive. They're designed to substitute, for, hey, I'm alive, but I'm in a condition that I can't make decisions. I can't do things like that. The healthcare one is really, that's specifically designed for healthcare issues, obviously. This is who can speak to the physician, who can make decisions about what treatment's given. And actually, they look harder at withholding treatment. If you say, no, I don't want my person to go through that, they actually really insist that that's documented. The bigger risk as far as finances and so forth is the financial powers of attorney. I specifically always, and again, this is individual, but I always try to tell people, hey, you should put a clause in there that says this authority doesn't kick in unless I'm declared incapacitated by 2 independent licensed physicians.
Right.
Otherwise, if you don't have that clause in there, power of attorney can go right to the bank and start writing checks.
Yeah, I prefer that for all powers of attorney, actually, or all incapacities.
Yeah. Typically put it in the healthcare ones only because it doesn't contemplate an emergency. You don't want to have them declared incapacitated if there's an emergency situation, but it doesn't hurt. Financial ones, I would say always. I agree with you 100% of the time, I would say, because that's also when people start looking at it, right? When someone's incapacitated, that's when people start looking. If you're alive and well and doing your own thing and somebody's writing checks out of your account, nobody's really monitoring that because you're not incapacitated. It's you. But that's, what you become, once you're incapacitated, then the power of attorney is subject to that on your behalf and in your best interest legal standard. And that's where they will look at, hey, what are you doing with this money? Why are you spending it? How are you spending it? You need to account for these things.
I have 2 things I want to ask about, and it doesn't matter if you answer them right away or later on. I just want to say them before I forget them, because that's what happens when you're almost 54 and you're me. But one is, what is the look back period that people are always afraid of, Medicare, Medicaid, whatever that is? And the other item was, this was probably for L, because you're in Oregon, and this doesn't apply to everybody. But I believe Oregon has a legalized assisted euthanasia statute. And I think there might be only 2 states that do. I think one is Oregon. I could be wrong. But
no, I think you're right. I haven't had occasion to look into it, but that sounds right.
How does the healthcare directive play in with the assisted euthanasia, or is that an exclusion that has to be the person themselves declaring for themselves? But if you don't know the answer offhand and you want to poke around and look for it to buy sometime, that's fine. And if by the time we get it around to you haven't been able to find it, it's okay to say, I haven't. It's not that easy to find.
From what I recall, and by recall I mean I heard a lecture on this or read an article or something. So this is me remembering things. Is that in order to be allowed to participate or to essentially get someone to help you terminate your life, you need to make an application to I don't know if it's a judge or a magistrate, or basically it's like you can't just wake up and decide. You have to apply for it, and in order for you to do that, you need to be competent enough to assist in your own defense or what have you, which has caused a lot of issues because if you're dying from cancer and you may not, I don't know if it's testamentary capacity that they're looking for, which is different from, and you guys can chime in on that, testamentary capacity versus however that works out. The system is not perfect, but it's not something your power of attorney. Obviously, if you're incapacitated, there can be provisions for pulling the plug, but
right.
I think you have to make an application to do it. Actually, can you hold on 1 second?
Sure.
Because I might have an answer to that.
That's fine. Yeah. So, but if she's correct, you can't do it through the healthcare directive. You must do it in your own proper person. Okay, that's fine. Rob, what about the look back period that people are always talking about?
Yeah, the look back period applies to. So the way to differentiate it in your mind is Medicare is insurance, Medicaid is welfare. Medicaid, it's a 5-year look back, and what'll happen is they will actually go and, to your point before, where we were talking about filing claims against the estate. If you end up in a situation where you're on Medicaid, when you pass, they will actually file a claim against your estate for the benefits paid you while you were alive.
Okay.
And they become a creditor like anyone else. Now, I would be willing to guess, not 100%, but I would be willing to bet that if you're in a situation where you are receiving that, you probably don't have much of an estate for a claim to be filed against. But that's not always the case. So that's something to keep in mind. A lot of people are like, oh, I should give away all my stuff and get on Medicaid. Well, that's great. But if you do that within 5 years, then you end up in a Medicaid facility and you live for another 5 years. They're going to come back after their piece of the pie. And they will do it through a regular creditor estate claim. But because it's a state taxing authority, they're going to actually have precedence over like a credit card or an auto loan or anything like that. So there's a specific, at least in Maryland, and I know there's in other states, I just don't know what they look like in the other states, but there's actually a specific order in which creditors get paid if there's an illiquid estate.
Okay. Is there any minimum threshold that you have to have assets that could total $100,000 or $50,000 or $250,000, or is it just subject to whichever collector happens to be reviewing that file?
Yeah, there's really not a certain amount. I tell everybody that you all need this because the unintended consequence if there's no documentation is almost never what you would otherwise want to have happen.
Okay.
So it's not really a matter of assets, especially in second marriage situations, like you said before about the new gold digger and things like that. There are things where it's an automatic, but I would say everyone needs to have something. Even if you don't have a lot of assets, you still need financial power of attorney, healthcare power of attorney, all those things in place because, especially with healthcare now, doctors have gotten to the point where they don't want to tell anyone anything.
Well, and also in kind of a situation, I would say a situation like mine where I don't have a spouse and I don't have children, it would, in a situation, I assume in this state is the same as Maryland would be, it would revert to the decision-making power would go to my parents, correct? Like they would be the ones who...
If you didn't have documents, they would have no authority. The court would tell them who gets what.
Okay, so, but theoretically, that could cause a bit of a problem, and I love my parents, but we don't see eye to eye in a lot of philosophical things, so I have my sister down for everything, even though in that past scenario, I actually didn't know that it didn't revert.
No, there's actually in fact, they don't even get automatic personal representative authority. But what'll happen is, the court, you should be able to look it up in whatever state you're in. So for you, just put in Oregon laws of intestacy, and it should give you a flow chart that says, okay, if X and Y, then Z. So like for you, if no kids, no spouse, then it might go to your parents, and then if your parents weren't there, it might go to your sister. So the flow chart will spell out very specifically here's who gets what. And they designed that specifically for people that haven't done documents, just so there can't be an argument. Right. Those laws begin, and that's the law, and there you have it.
And the executor, the personal representative, that's a best interest of the the court decides that on who they think is the best person for it. So if the family is all fighting, they may decide that nobody in the family is appropriate for it, and that's another way that the estate, modest or otherwise, gets further depleted by this outside personal representative.
Yeah, and I've actually been appointed personal representative in states like that, and they don't, the court just basically says you have to pay them out of the estate.
Yeah, so Elle, your solution is just to gift everything to Rob and myself in equal portions.
Well, yeah, and unless you want to make some really hard healthcare decisions for me when general anesthesia goes wrong.
Well, what makes you think that they'd be hard for me? I mean, my nickname is Evil Dose. I mean, so...
Yeah, would people be allowing me to live? Oh, sorry.
They won't even let us without proper documentation.
You mean if I can't execute a medical power of attorney that has my neighbor as...
No. You can. I'm saying, if you're already in that state, you don't have one. That's where a real problem becomes.
Yeah, I have to update that pretty quickly.
Some states will still allow a spouse to make a decision, but even now they're fighting that even more.
Well, I have an existing medical power of attorney in another state. So could they look to that for guidance?
They could some places may even honor that, as long as the state laws aren't wildly different and the execution was similar.
Yeah.
Before people get hurt in other states or something like that happens. So that 9 times out of 10, though, at least they just want to have something in their hand that says they have the right to talk to someone.
My answer to that is maybe, even probably, but not definitely. So if you're moving to another state, you want to talk to a lawyer in that state and get a definitive answer there, or it's always safer rather than sorry to have documents done in that particular state. And it's an additional expense, but it's less expensive than the alternative.
That's exactly. And I've had one kicked out by someone from another state because one state required the healthcare power of attorney to be witnessed, but state B, where they were now, required it to be witnessed and notarized. Right. And because the one from state A was not notarized, they said, guess what? This doesn't meet our execution requirements. It's no good.
That's right. Federalism is a tricky thing, as I think we've all gotten a crash course in. Even lay people have gotten a crash course in that recently. But anyway, what are some other big concepts that we absolutely should be discussing today?
Well,
I would go ahead.
Oh no, I was gonna jump on my favorite pet project, which is the Special Needs Trust, which is something I think you and I talked about as well back when we were sharing an office building. And this is something because I'm sure not everybody, but anybody who has reason to live through this, any kind of state or federal benefits for disability or social security or any kind of state-based
public assistance.
Yeah, require an income threshold, or below a certain amount or above a certain amount you don't qualify, or you get a lower rate of return or whatever. So in a situation where you have a relative or whatever who, and I don't know if I guess it's different state to state. I don't know what they need for the person to qualify as a special needs. But what?
Yeah, I was going to say every state is different.
Yeah.
And every requirement for a special needs trust is different.
Yeah, and so basically it's just to be able to let this person have access to property or assets in a meaningful way, so they don't have to, and the system's broken, of course, but they don't have to be poor just to qualify for benefits if their assets are being held and distributed through a special needs trust. And you guys can talk more about that, but I just thought that was an interesting little something that I stumbled over, which I thought was really interesting.
Yeah,
my thing.
Rob, you go ahead. You're the guest.
Cutting in and out a little bit. The big thing there is, again, if you don't do documents and you have a special needs child and they inherit money because you didn't do a document, the intestacy flow chart says they get money. Well, now their government benefits are cut off, and they're cut off until the money they inherited is depleted, and only then can you apply to turn those benefits back on. And not only that, if that never happens and that person passes with money, whoever was paying their benefits will come and claim that. So it can be a real disaster if you have that situation and don't do any planning.
Well, also, even if you have documents but you don't have a special needs trust set up, that person's still inheriting, and basically the goal of the special needs trust is to allow the special needs person to continue to get all of their or maximize their special needs payment, whether it's monthly or every other month, by only paying out from the trust the maximum amount allowable or less per month to not jeopardize their assistance, their public assistance, and that way you can maximize it for the longest period of time. And maybe they outlive the ability of the trust, or maybe the trust outlives them, but you don't want to jeopardize their ability to get money. So I think in Maryland now it's somewhere in the neighborhood of $2,500 a month that they can get. That's not exactly right, but so the trustee would pay up to $2,500 to that for that person's benefit, but they'd still get their full 100% public assistance. But if they say they inherited even a modest estate of $50,000, now they're not going to get any public assistance until that $50,000 is gone through, and then they've lost their nest egg.
Correct, and that's exactly why you have to consider that when you're dealing with that type of situation. I mean, that's really, if that doesn't drive you to do something properly, and people forget about things like they'll have them on as an IRA beneficiary, or they'll, oh, I don't have a lot. Well, guess what? Your assets, your house, your personal property, that you've created a problem for this person. So those things have value.
Right. And so if you have, go ahead.
Can a trust like this own property? Like, if there's a house that the trust owns a house that the person lives in, is that something? Can that? I mean, I guess it's different wherever, but I'm just curious, like, if it's just for paying out, or if it's like a situation where it can, hold money and non-money property.
You mean, could they get benefits that have a monetary value, like free room and board?
Yeah, something like that. Or would that? And I guess that's something that I have to look into. It's just something that I'm kind of thinking of in the moment.
Rob, I'll defer to you.
Yeah, I mean, big specific stuff. You would have to look at where you are, what the locality says regarding those rules of ownership.
I mean, if it's an irrevocable trust, I would think the trust still owns the property, so it wouldn't be the recipient's property, so it wouldn't be counted against them. Just like if they lived in their parents' house, you're not going to have rent imputed to you. But it could vary from state to state. But that was a good one. Rob, was there anything that you were thinking about? Any things that we really should be talking about and addressing here?
But no, I think we've covered a lot on this topic, which is good, because I can't tell you. I always tell people I have a lively planning practice, which I like. I enjoy doing that. And then I have a whole other side of my practice, which is dealing with people that don't do these things properly. And it's the disaster. The court will find a resolution, right? They're going to say, well, here's the intestacy chart, or here's what this says, and here's what people don't consider is the family is not the same. If you spend, 3 weeks in court screaming at each other because, grandpa's car should have gone to one person versus another, that stuff doesn't get fixed, right? So it's just not worth it not to leave this out in the brief.
Right. And it gets especially, everything's bad, but the one I encounter time and time again is where one sibling has been living with mom and taking care of mom for the last 3.5 years, but the other sibling has been more or less financing that, and they argue about which has more value. And that's something that nobody can ever solve, and it's pretty hard to recover from stuff like that. And the more siblings or the more grandkids or the more people involved, probably the worse it gets.
Yeah, the same.
So I agree with you. We are coming real close to an hour, and I think if we started getting too much longer, I think people are going to glaze over on this subject, especially lay people, which is what this show is geared towards. And we couldn't say it more times to say things are state specific, sometimes county specific or municipality, and certainly get the advice of your own attorney. If you're in one of the jurisdictions that our guests are licensed in, or I'm licensed in, you can contact us and we'd be happy to talk to you. I'm lazy. I would shuffle you off to our state's department. I'm a sourcer. I'm not a doer. That's why I have podcasts. But I'm going to let our guests introduce themselves again, or remind you of where you can get in touch with them, who they work for, and where they're licensed. If you want to get in touch with them, I'll go in alphabetical order. So I'm going to start with Elizabeth Burlington, Esquire. And LLM, right? Aren't you LLM also?
Yep, I am an LLM. Got my tax degree, which out here on the West Coast there are not as many LLMs, so I'm somewhat special. Not really, but like I think I am. So again, it's Solar Whitman Cooper, solar spelled SOHLER, not like solar panel, and that's where I am. And I have a Murder, She Wrote podcast that's on hiatus because it's impossible to get three busy people on a podcast together.
You're kidding.
What?
You're kidding.
Whatever.
We only rescheduled this pod 4 times.
Right.
And in the meantime, just hanging out in Portland. So, come say hi.
Sure. Everyone just go to Portland and say hi. Rob, how about you?
So I have my own firm, as we talked about at the beginning. It's Rob Owings, OWINGS, Law. And the website's the same, robowingslaw.com. I'm not big on creativity, so all of it matches. So, yeah, you can just reach out to me on the website. The email address, the phone number, and so forth are on there. I'm licensed in Maryland, D.C., and Pennsylvania. Working on Virginia, but I don't have that yet. So Maryland, D.C., and Pennsylvania for the time being.
I should also add that Rob did my estate plan when that was like, 2 years ago, something like that? Because I was getting ready for surgery. Yeah, it was. Yeah, I get to have surgery again, probably. So, hooray!
You're like a box of chocolates.
You're going to be fine.
All right. Well, do you guys have social media? Anything you want people to follow you at, or we all good?
Yep. My law firm has its own Facebook page and Instagram page. Again, both Rob Owings Law, easy to find. I'm on both platforms, so give it a follow.
Yeah, Rob, I don't think simplicity is uncreative. I think if you get too creative, that is the enemy of simplicity. I think in marketing, simplicity is very good. So, and Al, how about you? I don't think you gave the name of your podcast that's on a hiatus. I mean, there's a catalog if people want to listen.
It's called Murder, She Woke. We've done 1 season and change. It's just, there's a lot going on with all of the hosts, and I think we're going to wait for the new year to see if we can get our shit together, because right now it's just impossible to get everybody together.
Yeah, but if they wanted to check it out, they'd have a season and a half to go through, and maybe by then your stuff will be together.
Two millennial attorneys talk about a show from the 80s and 90s.
What's better than that? I'll tell you what's better than that. The 3 shows I did with my panel where we talked about Land of the Lost, and we got midway through season 2 and then left you hanging and didn't even get any further because it was too difficult to get all the people populated. And frankly, Land of the Lost was, it wasn't all deep and riddled with these secrets and clues like Da Vinci Code that I was hoping were embedded. Now it's just some stone guys who made a show. Anyway, for me, you can find me on Twitter at IcarusFellMD. The law firm I'm with is Dunlop Bennett and Ludwig PLLC. We have licensed attorneys in many, many states, but I'm Maryland and DC, but the firm has people licensed in Virginia, New York, Georgia, New Hampshire, West Virginia, Delaware. I think I said New York. I think other places too. I think like Colorado, Texas, et cetera, et cetera. And my other podcast, Garden of Doom, if you're listening to Garden of Views, there's a pretty good chance you already know about Garden of Doom. But if not, that is more occult, esoteric, things that go bump in the night, a little pop culture. Elle's been on 2 shows, Star Trek 101 and Star Trek 201. So that's, I would call that pop culture. And I also have a whole lot of wrestling podcasts. If you're interested in that, just tweet me, DM me, and I'll tell you what those are. Otherwise, you're probably listening to a podcast about estate planning and going, why would I listen to a guy who talks about wrestling? So I probably should have left it out, but I am who I am. All right. Rob, Al, thank you very much for joining us. Folks, hope you found this valuable. Once again, talk to your own attorney, get your own advice, the advice of your own attorneys. This is not a substitute for legal advice. You've heard a lot of the idiosyncrasies, both jurisdictionally, and this is not isotoner gloves. It's not one size fits all. Estate plans are plans for you, tailored for your needs and the needs of your family. So with that, I thank you all for listening, and please like, rate, and subscribe, and listen to us next time on Garden Views or Garden of Doom.
Thank you.
7 years young, my daddy said, son, if you're gonna be dumb, you better be tough. Don't ever start one, but throw the last punch. And hit them hard enough so they don't get up. Early to bed and early to rise makes a man healthy, wealthy, and wise. I shake my head and I roll my eyes when he starts talking about things like death and taxes. The world moves fast and money and time, it don't grow on trees. Make your bed and say your prayers, 'cause life ain't fair and it's never gonna be. Chicks dig guitars, tattoos and scars. Trucks and cars don't run on dreams. You can count on one hand the things you can count on: death and taxes and your mama and me. I went from 7 to 27. Time flew fast, just like he said. It's kinda crazy. I got a baby across the hall, sleeping in his bed. I'm praying prayers I never thought I'd pray about, saying things I never thought I'd say aloud. Man, if my old man, he could see me now, he'd shake his head and laugh, 'cause he was right about death and taxes. The world moves fast and money and time, it don't grow on trees. Make your bed and say your prayers, 'cause life ain't fair and it's never gonna be. Chicks dig guitars, tattoos and scars. Trucks and cars don't run on dreams. You can count on one hand the things you can count on: death and taxes and your mama and me. Death and taxes and your mama and me. Ooh, crazy how I'm talking about death and taxes. The world moves fast and money and time, it don't grow on trees. Make your bed and say your prayers. Life ain't fair, it's never gonna be. Chicks dig